Welcome to Literary and Jury Charge Practice. Let's start out with this opening statement. Ready? Here we go. Good morning, ladies and gentlemen of the jury. My name is Andrew Stevenson. I indicated earlier I represent one of the defendants in this lawsuit, Baltimore Tank Lines, and I'd like first to thank you all for being here today and for doing your service, your civic duty as jurors. It's a very important role, and my clients certainly appreciate it. I know it's inconvenient in this modern age to have to give up a whole day to be a juror, but rest assured we're grateful for it, and it's probably going to be just a one-day trial, so hopefully it won't be too much of an impact. And there's really only 3 witnesses in this case. You're going to hear from my client's driver, Mr. Danny Quaid, and you're going to hear from Ms. Cindy Young, and you're going to hear from the plaintiff. No expert witnesses, no other witnesses to hear from. There's a few exhibits you'll have the opportunity to review, and that's pretty much going to be it. And you're the trier of fact in this case. The judge determines the law, but you have to determine what the facts are, what happened in this case, and I trust that you'll reserve your judgment until you've heard all the evidence. The plaintiff in this case has the burden of proof. That means they've got to prove to you that it was more likely so than not that their version of events is true. We don't have that burden. So you're going to hear the plaintiff's going to put on their case first, then the defendant will have the opportunity to put on their cases thereafter, and we trust that you'll keep an open mind throughout the entire process and reserve your judgment until you've heard all the evidence, and that you'll treat all of the parties as individual parties. I'm the only one that represents a company in this case. The other 2 parties are individuals. Not only do I represent a company, that I represent a tractor-trailer company. In fact, that's what I do for a living. I represent tractor-trailer companies. In my experience, sometimes I find that folks don't like tractor-trailers, so I just like to be honest about it. Folks don't like tractor-trailers. They don't like driving next to them. Not a popular type of client to have, but I trust that you will put any of those types of feelings aside and you'll just weigh the evidence as you receive it. Now, in this case, plaintiff's counsel showed you 2 exhibits. These are blow-ups of exhibits that will be admitted into evidence in this case. After all of the testimony was taken in this case in deposition, I retained an engineer to go out and measure the scene where this accident occurred, and this is what was produced from those measurements, and those diagrams was the exhibits that will be admitted into evidence. Now this is what our engineer has run up, and there's a bunch more exhibits, and this is another one, but this depiction here where the plaintiff has put his version of what happened, where he's placed the vehicles on that's what they have done with one of our exhibits. We are not agreeing that that's how the accident happened. In fact, we have a very different version of how it happened. It's important that you note that this exhibit where the plaintiff has indicated this is where the accident happened, that's slide C. Let's put that down for a second. So in terms of the larger blow-up, the plaintiff is indicating slide C that the accident happened in and around this area here. Okay, it's important that you understand that that's what they're saying here today. But through the course of the trial, you're going to hear testimony. Just so you know, that's about 760 feet away from Leonardtown Road, and you've got a scale here, and you can calculate that and work it out when you get the exhibits later on. But I've done the math, and it's about 760 feet away from Leonardtown Road. Today during the trial, you'll hear that we had depositions taken in the discovery process. That's the sworn statement under oath where we created written transcripts in this case. And at the deposition, the plaintiff was asked, where did this accident occur? How far from Leonardstown Road did this accident occur? and he was very specific and very emphatic. It was 80 yards. 80 yards is 240 feet. He likened it in his deposition to about a football field, about a football field's distance from Leonardtown Road. I've done the math, and you can do it again. You'll have the exhibits. They'll have scales, and you can work it out, but 240 feet, right about there, right about 500 feet away from where they're saying the accident happened here today. That's the type of thing you're going to have to consider in terms of weighing credibility and weighing evidence in this case. You're going to hear from my client's driver, Mr. Quaid. He lives in Clements, Maryland, here in Charles County, been a professional truck driver for over 25 years, married 20 years, got 4 kids. He owned the tractor involved in this case. He's what they call an owner-operator. He leases his tractor to Baltimore Tank Lines. You're going to hear, similar to the plaintiff, Mr. Quaid drives down Mattawoman Beantown Road and makes a left turn onto Leonardtown Road every single day. That's how he gets home. He lives in Clements, and he drives down that road, then takes Leonardtown South to home. You're going to hear he was very familiar with his tractor. He owned it. It's the same tractor he drove every single day. But here's where our version of events differ. Unlike how the plaintiff showed the accident happening, Mr. Quaid will tell you he drives down Mattawoman Beantown Road where there's 2 through lanes. He always stays in the left of the 2 through lanes. He's got to make his left turn also from the right of the 2 left turn lanes because he's driving a 60-foot tractor trailer, and he can't make that turn from the left of the left turn lane because it's too sharp of a turn. He has to make it from this lane here, and every day he drives down here, he does the same thing. He comes down this lane here and merges straight across into the left lane. This isn't the type of this is exactly why I went out and had engineers prepare these detailed diagrams, because I don't want you to misunderstand that this is the type of road where you got 2 through lanes here and then it widens off to the left for the left turn lanes. That's not what happens here. This is a merge situation. There's no lane change involved. He drives straight into the lane he needs to go into, and he'll testify he just has to keep his steering wheel straight. In fact, if he wanted to stay in one of the through lanes, as he'll testify, he would actually need to steer to the right to remain in that lane. There's no lane change. Now, according to the plaintiff, you got Mr. Quaid coming down the through lanes, going off into the right through lane, coming back over. He's got my client coming over here, making a lane change here. In other words, he's suggesting that Mr. Quaid would have ignored the merge, come all the way around totally, and then made a lane change. Mr. Quaid will say he never does that. That's absolutely inconsistent with his regular routine practice. Now, there are salient facts in this case, and here is the first one. This is probably the most important fact in this case. The plaintiff has admitted, and I assume he's going to testify consistent today with his deposition transcript, that he was driving behind the tractor trailer all the way down from 301. He's following behind. He admits he was directly behind the tractor trailer all the way, tried to get ahead of him back at the turn, however, but he was behind him for at least a mile prior to this occurring. So if he's behind the tractor trailer, how is it then that he gets into this scenario that they have described here where he's getting ahead of the tractor trailer? The only explanation I think that you can reach in terms of the evidence that will be presented today is that Mr. Irvin tried to speed around and overtake the tractor trailer on the inside as he was merging, left himself with no room, and then out in front of Ms. Young, and apparently applied his brakes too at that point. He didn't accelerate on when he moved into this left of the left turn lanes because he was rear-ended by Ms. Young, who was, by her own testimony, which is undisputed, going about 35 miles per hour. That's the first most salient point, that he admits he was driving to the rear of the tractor trailer all the way down. The second most salient point In this case, you will hear, I think you've already heard it from Mr. Ford, Ms. Young will testify that despite this close scenario here that the plaintiffs allege that happened at, understand that D there is for Dodge. That's Ms. Young's vehicle, the Dodge. H is for Honda. That's the Honda Accord that Mr. Irvin was driving. Despite this situation here where a tractor trailer is by Mr. Irvin's testimony cutting across down on top of the Honda, forcing him into the lane, Ms. Young's going to testify, never saw it happen. Absolutely inconsistent with normal human experience and perception. You'll ask yourselves that 60-foot shiny tanker trailer with a silver tank coming down on top of you, and she didn't see it. She would have been 5 or 10 feet away from this tractor trailer during this entire scenario, and she didn't see it. Now Mr. Quaid will testify he has no knowledge of an accident. We admit that we looked at the record, and yeah, Mr. Quaid, he lives in Clements. He was the most likely person to be. This lawsuit and claim is our first notice that we're allegedly involved in the accident. He has no recollection of seeing an accident, and certainly it is undisputed there was never any contact between the Baltimore Tank Line's tractor trailer and any of the other vehicles. That is not even in dispute. He will testify he has no recollection of an accident having ever occurred. So that is the evidence you're going to hear today, and I think that you will find in weighing that it's more likely so than not, or you can't make a decision in the scales of justice are evenly balanced in your mind that he hasn't met the burden of proof and tipped them in his favor. It's more likely so than not that the tractor trailer did the obvious easiest thing by just merging straight into the right of the 2 left turn lanes, which is what he did every day and what he needed to do in order to get home. And that if the plaintiff, by his own testimony, was driving behind the tractor trailer, there is no possible way that this accident scenario that they've concocted in this exhibit could have occurred. With that, I thank you again and look forward to closing this trial up today. All right. Next, let's try some literary practice. This is called The Woman with the Silver Ring, Jane Doe. Ready? Here we go. Her body was discovered 49 years ago, but her identity is still unknown. A woman dressed in purple capri pants and a colorful blouse was discovered in 1968 in a Huntington Beach strawberry field. She had been beaten and her throat had been cut. The case is Orange County's oldest unsolved homicide involving an unidentified victim. Steve Fulmer, who was then 10 years old, was looking for lizards and frogs in the ditches near his house when he saw 2 boys hovering by a body covered in a black coat. He first thought it was a mannequin. The boys ran to a nearby neighborhood, told residents what they had seen, and the police arrived. Fulmer later spent 20 years as a Huntington Beach police officer. He would often patrol by the site where the body had been dumped and wonder about the case. I have a lot of pride in the fact that this case hasn't been forgotten, says Fulmer, who retired in 2003. It would be easy just to say it's unsolved and stuff the case in a file drawer, but the detectives are still investigating. They haven't given up. DNA from a male suspect obtained from the crime scene was submitted to the FBI's National DNA Database, CODIS, but there hasn't been a match. The Orange County Cold Case Homicide Task Force held a press conference in November 2016, sharing information about the case and releasing a photo of the woman, hoping to learn her name. She was white or Latina, between 20 and 30 years old, with dark shoulder-length hair. Investigators believe she was from the East Coast because some of her clothing was distinctive and only made in upstate New York. She was wearing an inexpensive silver ring with a light blue stone. Don Howell, the retired Huntington Beach detective who works part-time with the Cold Case Task Force and is working on the Teresa Baxter case, says identifying her is key because it will help him determine other details of her life, if she had a boyfriend, where she worked, and who her friends were, all of which might lead to the killer. So many detectives have worked the case for so long that when Howell calls the crime lab and asks about Jane Doe, they all know to whom he's referring. The suspect who sexually assaulted the victim fits the profile of a serial killer. Howell is surprised there hasn't been a DNA match. He has few answers and many questions. Was the killer drafted, and did he die in Vietnam? Did he flee to another country? Was he incarcerated before inmates were required to submit DNA? Did he ever offend again? He believes there must be a friend or a family member who could identify the woman. He wishes they would call him. Excuse me. Sorry. All right, let's get to some jury charge material. Little jury charge practice. Ready? Here we go. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind, so the law says that criminal intent may be inferred from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence is the testimony of a person who asserts or claims to have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. The law makes absolutely no distinction between the weight or value to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all the evidence in the case. After weighing all the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Normally, a person cannot give opinion testimony. Normally, when a person testifies, they must testify as to what they either saw, heard, sensed by smell, or something in that nature. However, there is an exception when someone is qualified because of education or experience. They are permitted to give their opinion in certain areas if the court qualifies them that way. In this case, witnesses have been qualified to give opinion testimony. This does not mean that you must accept the opinion, but it is evidence for you to use in any way you see fit and for you to give it the weight and credibility you believe is appropriate. A statement alleged to have been made by the defendant has been admitted into evidence in this case. While the court has determined that the statement is admissible, I instruct you that you make the ultimate decision of whether or not the defendant made this statement. If the defendant did make the statement, you must determine whether the statement was made by the defendant voluntarily and of his own free will. This means that the statement was not caused by pressure, force, fear, threats, coercion, or intimidation, or by hope or a promise of leniency or a reward of any kind. In determining whether the statement was voluntary, you should consider both the characteristics of the defendant and the details of the questioning. All right, we will stop there. That will conclude our literary and jury charge practice.